Good afternoon and thank you for having me here. The presentation that I'm going to do is split into two sessions. I do one now for about 45 minutes, running up to 1:30 and lunch. And do a second one soon after lunch, I think about 2:30 to 3:30. I speak for myself and I speak for a very small team that we've called the RTE Hub at the Law and Governance Initiative in APU. The presentation that we have for you today is split into two parts. The first one is called Implementing the RTE, looking at the statute and the Supreme Court. And the second is about rules and implementation, that's rules and institutions. And so there's a considerable amount of detail behind the presentation which we can't really do in a one-hour slot. So we'll attack some problems that we think are interesting and important, and then look to all of you to tell us what your priorities are and what we think might be things that we should collaborate on and act upon in the months to come. Let me just start with a brief question. How many people in this room have read the Act? 1, 2, 3. Read the Act in full, you think? You'd be reasonably confident about the structure of the Act. So that's about 3 to 4 people in a room of 30. So, then the purpose of this, the first half of this presentation is still useful. How many of you have read the judgment? The Supreme Court's judgment on the RTE. Many of the questions that Rohit was trying to work with you on this morning are dealt with. To some extent, I'm not saying dealt with well, but they responded to the judgment. And in some ways, judgments are forms of public reasoning where state institutions give reasons for why they pursue particular policy. Very useful to read it. At least it helps us clarify our own reasons why a particular policy is useful or not so useful. So the judgment, almost no one has looked at. So I hope that the short presentation that we do in the next 30 minutes will be useful for you to at least, I hope it will invite some of you to go off and read this judgment, which is easily accessible on the internet for anyone who cares to look. So that's what we're going to focus on in the first section. I want to try and work through the structure of the Act, point out what's different in this statute, and what part of it has been upheld and what you might look for when you look to see the implementation of the Act. Unlike Rohit, I mean, I've left all the big questions to Rohit, it seems, because the first session he was trying to work through some of the foundational questions that it's very useful for people to have convictions about before they enter this part of the debate. Right? I don't know if I'm blocking your view of it. So let me start with the statute. Many of you know that the RTE Act was enacted in 2009. As Rohit mentioned, by the time the legislation came about, he had moved away from the issues, and many people who had worked on these issues for many years had actually almost given up in some ways. But there's another striking thing that happened with the date of the Act, 2009. You must remember that by 2007, Sarva Shiksha Abhiyan at least reported enrollment rates in the high 90s. Right? So you might really ask yourself what the Act was about. Why did you need an Act after enrollment rates have reached 90%? So what is the Act about? The remaining 7% of enrollment that you need to achieve? What is the motivation for the Act? It's a useful question to ask. And we'll try and respond to some of that in this presentation. I'll just come back to you. What I'll do is I'll just do each slide, and if you have questions about the slide, please ask me and we'll talk about it. So the first thing that the Act does is that it takes executive orders, the executive structure of education policy, and makes it statutory. Now you might ask, why does it take 60 years to do this? But anyone who knows the history, the legal history of education would understand that education was a state subject. States were free to deliver universal, free, compulsory, whatever it was, education for many, many years. So the useful institutional governance question to ask is, why states didn't do it? So what changes in the RTE Act is a slow moving away of the subject of education from state competence to concurrent competence of the state and the center. It's only when the state and the center had concurrent jurisdiction, and for those of you who remember your constitution from civics class, it's list 3 of the 7th schedule. It's only when that happened that education in the elementary sector really began to happen in India. So long as it was the responsibility of the states, enrollment rates were in the mid-30s to 40s. And it starts to change, the uptick is when central resources and central regulation comes in to this sector, in the elementary sector. Right? But the statute does something interesting. It takes what is an arena of executive policy and creates statutory rights. Please don't confuse this, and there were many people who spoke in the morning talking about constitutional rights and natural rights. As far as I know, our constitution doesn't guarantee you natural rights. So no matter what you think your natural rights are, they're not guaranteed. Right? We can all believe we have rights to many things. And it doesn't matter what we believe in some technical legal sense. The second thing that I want to point out is that it doesn't really matter what the Supreme Court says, what rights we have. Because the Supreme Court has gone about giving its citizens all kinds of rights. But if you want to look at enrollment levels and the Supreme Court's pronouncements on the right to education, there's no impact. Supreme Court said that we have a right to education in 1992 in the first instance, repeatedly in 93 and 94, nothing happened. You want to look at the DICE statistics and look at the enrollment figures, the Supreme Court judgment has no impact whatsoever on the delivery of education. What really changes the enrollment figures and what this Act tries to capitalize on is the creation of statutory rights. How are statutory rights different? Statutory rights are different because you create institutions for their implementation. That is, when your statutory right is not fulfilled, you have somebody to go to. You have a structure by which you enforce your statutory rights. Notably, in countries like Finland and Sweden, there are no constitutional rights to education. There are only statutory rights to education. No one has to make some broad aspirational claim that I have a fundamental right to education. This and that is unimportant. What matters is, do states create enforceable statutory rights, and will they put the funds behind it? These are the relevant questions in the achievement of social welfare. And the Right to Education Act, which follows the National Rural Employment Guarantee Act, crystallizes a new strategy for the achievement of welfare. The strategy of statutory backed and legal entitlements. Right? And so, in some ways, new welfare, that's the right to education, it's the first test case for a new model of delivering basic social welfare in this country. And if you ask where does it draw its inspiration from, it draws its inspiration from Scandinavian social democracies, which have strong statutory provision of welfare. What difference does this make? And I don't know. I mean, maybe as a lawyer, I intuitively get a sense of the difference, but maybe I should explain. When you have executive policy-based welfare, the executive officer in charge can always decide whether they deliver the welfare entitlement or not. In statutory entitlements, the executive officer can no longer decide whether you are entitled to the entitlement or not. And with the universal entitlement of the right to education variety, they have to provide it, because there's no other criterion except that you're alive and you're in the age group. Right? So that's the key difference between having executive policy and having statutory policy. The second element of a statutory scheme is to insist not on political accountability. In a sense, the new welfare statutes signal that political accountability in India has failed. Right? They are an admission that the idea that you will somehow mobilize your local panchayat and your local district magistrate or whoever it is and deliver welfare, that has failed. We have dime a dozen welfare schemes from 1950 which have been delivered on the old model of political accountability. That is, ultimately you get your MLA to get it enforced. It happens at the fringes. What we do know is that that model of welfare substantially failed in India. The second, the bet here is to back up political accountability with legal accountability. Now, will legal accountability do any better than political accountability? I don't think the answer is obvious. But I think what many of the people in this room do will make the difference on whether legal accountability is going to do any better than the history of political accountability in India. I mentioned the third element, which is moving from a state to central funding and supervision. Why is this necessary? It's not necessary. If state governments were motivated to the delivery of basic welfare, then this would have been a different country. But clearly state governments, any honest and fair account of the political economy of state governments in India would have to admit that state governments have been very busy doing other things. What other things differs from state to state, but it's pretty clear that unless you take, if you only take out Kerala and some West Bengal on a few items of welfare, most state governments have been very concerned about other issues in politics and not the delivery of basic welfare. What does the statute do? It creates a right to free and compulsory education, and that is a right of a child. Right? So that's the core of the statute in section 3, and chapter 2 talks about the various variations of that right. What if you have disability, or what if you need to transfer from X school to Y school, and so on and so forth. And I'll invite you to just look through the details in chapter 2. But the way the right is enforced is through this four-pronged strategy of imposing duties on various actors. The structure of the Act, and this you need to understand, is built on these four prongs. So when you read the Act, please notice that the schools, the state, the parents, and the teachers all have statutorily defined duties. So let me quickly run through what these statutory duties are. We need a power source. Hopefully it will last till we go on. Each of these elements, when you ask the question, whose duty is it? It's a good way to read the Act. Right? It's not some bland thing that says, let's make sure that, and this is the general quality of public discourse, so, some teacher either uses corporal punishment or punishes a child in a certain way that is treated as offensive. The standard refrain is that you either you get that the government is responsible, A. B, that the school is somehow responsible. C, that we must find a way of either using the criminal law or some other such mechanism to get it enforced. Right? You get this kind of bland blaming of institutions without an attention to the structure of the Act. So what I'm trying to do with this slide is to just invite you to think about the structure of the Act. Right? What's the problem? No problem. I'll stand this side. Is it working? That's fine. Sorry about that. You just put it over here. Okay, just put it over here. So you've got your mid-talk break, and so let me get back. So what I was suggesting to you is that the way the right is enforced is through the imposition of duties on discrete actors. These duties are different duties, and each of these duties is enforced through a particular institutional structure. And unless you understand what the duties are and which institutions are responsible, you can't really get thinking about how the act is implemented. So the first thing deals with the state. Now, the state has three basic obligations: to create schools, to fund these schools, and to structure the norms for the recognition and administration of schools. These are the three primary duties of the state, and is set out in great detail in Chapter 3. The schools are responsible for a non-discriminatory admission process, that they must admit children who come to them, in the case of state and aided schools without any limitation, but in the case of private and unaided schools with some limitations, and you know about the 25% quota. No fees in state and aided schools, and fees are allowed in the private schools, but with some limitations on the 25% quota, and so on. Schools are responsible for creating school management committees, right? Though the rules will be created by the state government, schools must establish these committees. Then you have duties of parents, and parents have the lightest load of duties. They simply have to admit the child. Now it's interesting, and there's been a lot of research and writing about paternalism in state policy, and the Indian legislation makes no exception. There's no homeschooling exception or any such element in the Indian law, right? Everyone has to admit their child. And if they get elected to a school management committee, then they get to participate in the school management committee. Otherwise, parents don't have a significant role. Teachers have been, there have been a lot of obligations imposed on teachers, including commitments of regularity and punctuality, that they must complete the curriculum, and that their duties can only be, apart from teaching, that they are part of the decennial census and the election process, and no other duty should be imposed on them. And of course, like all bureaucratic statutes, there are exceptions that state governments and central governments can enlarge the range of duties, which I have no doubt that they will certainly do. The legislation was challenged, as that many of you may be familiar with. It's a case called Society for Unaided Schools in Rajasthan. At least that's the primary petitioner, versus the Union of India. The decision of the court was in February 2012. And let me just take you through a broad outline of what the challenge was and what the decision of the court is in this case. And I say this really for some of the reasons that Rohit was trying to work through. Why do we even have these debates? What are the kinds of obligations that the state has? What are the kinds of obligations that private actors have? It's useful for us to think about it because that in some ways shapes the way we look at the problem of implementation. The entire legislation was challenged by private schools. So the focus in the Supreme Court was only on one question, the duties of schools. No other questions were raised in this case. This is an important thing to remember because there are many other problems with the Act, none of which are discussed in this judgment. The primary focus of the schools, the private schools, was the disadvantaged 25% quota that they have to administer hereafter under this legislation. Their other issue was the new norms of recognition. Now remember that state governments already have legislations administering, they have an extensive education bureaucracy. There's already a mechanism for recognition and derecognition of schools in almost all states, administered by the state government. The Right to Education Act creates one more layer of recognition, right? And it's interesting to see what state governments do. Do they create a double structure of recognition or do they integrate the structure of recognition? It's not clear from the early evidence of how states will adapt whether they will create two different forms of recognition or just one. The other thing is that Schedule 1 lists all this range of infrastructure that should be provided in schools, right? So states, the private schools basically argued three things. First, that they should not bear the 25% quota, that the burden of the statute is to secure free and compulsory education in the state sector. Hence, the state must bear the obligation. The second argument was that all these new norms of recognition and infrastructure were an unjustifiable restriction on the scope, freedom to operate of the private school sector. And the third argument was that even if the 25% quota were imposed, that the state should pay the full fee. That if the states wanted the private sector to admit these students, then the state should pay the full fee. The statute says that the states only need to pay the state's cost per child, right? And these were the three main challenges in the case. I don't know how many of you were I know that Azim Premji Foundation is a fast-growing organization, so many of you may not have been a part of the organization in February. So I don't know how many of you were aware that we intervened in this legislation. And we argued in support of the legislation. And I just want to give you a sense of what we argued and why we argued what we argued. Okay? So the foundation was the only intervener in support of the legislation. All the other interveners and private actors were against the constitutionality of the legislation. That's the first thing that I think, the first notable point. The second thing that we did was that we argued that preschool education should also be included in the Act, and also that secondary and high school education up to the age of 18 should be included in the Act. If you look at the Act and the Section 11, preschool education is left as optional. States may develop a preschool education system. We were urging the court to interpret the may develop as must develop, that there should be a fundamental right to preschool education. If any of you have seen the literature on preschool education, I know many of you are in the education sector for a long time, you would notice that most arguments about social equality, the impact on social equality of education, seems to be disproportionately in the preschool period. It's very interesting that the impact for every dollar spent in the United States on preschool education is disproportionately higher than the entire, so 2 to 6 is more important than 6 to 14. And so we pressed the court that they should interpret the fundamental right to education to include the 2 to 6 period. The second thing that we asked the court to do was to enforce government liability. Because as Rohit had suggested, the government gets away lightly. It has no recognition. It is no problem. Even if it sets up a ramshackle school in which there is no infrastructure, it will always be recognized as a school. So we argued that the Section 18 recognition requirement should apply to government schools. So if government schools fail to satisfy the criteria set out under the Act, then those schools should also be wound up. Or they should invest enough to create schools of the quality envisaged under the Act. The third thing we argued was that the private sector could be asked to bear a burden for welfare. We made the only generic argument in the Supreme Court that when it comes to new welfare, private sector could be asked to bear these burdens, and this would apply in education, in health, or in any other sector where basic welfare was involved. So these were the three arguments that we made in court, and let me just tell you how the court settled the question. The first thing is that on the expansion of the right to include preschool and high school, the court denied the argument. It did not want to get into imposing obligations on the state to deliver preschool education and secondary and high school education. So what the court said that it would only deal with the negative argument of the constitutional validity of the RTE Act. So it refused to get into the positive dimension of what the scope of the right should be. The second issue was that it did not accept our argument on the enforcement of duties on the state. Now, the only support we get in Justice Kapadia's judgment is one paragraph where he details quite clearly that the state laws should be changed to make recognition of state schools the same for both private schools and the state schools. Right? So I think it's paragraph number 45 of the judgment, but no state has changed its laws, to the best of our knowledge. So the court doesn't create a new structure for enforcement against the state sector, but it provides an opening. It provides an opening for advocacy and efforts to implement the RTE Act against the state sector. The third element on horizontality, while the court cites Azim Premji Foundation in its judgment, and it says that they argued horizontality. While the court doesn't say that it accepted this argument, effectively the language of the court accepts the idea that social welfare rights can be imposed on the private sector, but with reasonable restrictions. It cannot be entirely imposed on the private sector, but it can be reasonably imposed on the private sector. And so the 25% reservation as well as the compensation requirement were both accepted by the Supreme Court. The Supreme Court created two minor exceptions. I don't know how minor it will be, depends on how states interpret. And the two exceptions created to the RTE Act are minority unaided schools and residential schools or boarding schools. Now, it will be very interesting when you look at the rules and how it gets implemented, whether these are narrow exceptions applying only to a few schools, or whether these are really broad exceptions which will take up almost maybe 50 to 70% of the private unaided school sector can possibly come under these exceptions. Right? So this is what the court held. Post the judgment, the one thing that we thought was important for us to do was to continue with this effort of looking at implementation of the RTE in considerable detail. So what we did was that we formed a small RTE hub at the Law and Governance Initiative with the idea that we would pursue 2 or 3 activities over the next few years. What are the activities that we do? The first thing is that we focus only on law and governance issues. We don't deal with the entire range of issues in the RTE. There are many issues that range from the philosophical to the political to maybe just being pedagogical, making pedagogical interventions in the RTE scheme, which are very important, but we don't do that. We just stay focused on issues of law and governance institutions in the case of the RTE. That's the first thing. The second thing that we do is that we run a small blog which we've done for about 6 to 7 months. But what we notice is that there's very little traction of the blog inside of the foundation. And let me be very frank about this. I mean, there's no point dodging it. It's very clear that what interests we have, it seems that at the present moment the foundation doesn't have. It seems that you all are doing different things, other things. I don't know what those other things are, and maybe we should talk about it just as I finish. But the RTE blog has done three things so far. One, we focus on RTE rules. Which state has made rules and notified the implementation of the Act, and what those rules say. Two, we look at other notifications issued to implement the RTE Act. And three, we track efforts at implementing the RTE Act and also opposition to the implementation of the RTE Act. For example, just 2-3 days ago, 16,000 schools under the Karnataka Unaided Schools organization have basically issued an ultimatum to the state government, and I think it's a good ultimatum, frankly, that the state government for the year 2011-12 has still not paid the compensation. And they have basically said that if the state government doesn't release the funds by the month of January, that they will not admit students under the RTE quota for the next year. Now, we may all have different views on the value or the lack of it of the private school sector, but what is very clear is that the next 5 to 7 years will define how public and private education will work in this country for the foreseeable future. I don't think you're going to get another effort like the RTE Act with all its flaws, right? So we keep track of these developments in the RTE Watch blog, and it might be of interest to some of you. The second thing that we do is that we hope to do some detailed research and advocacy support. We don't do advocacy. We are not in the business of meeting government officials and developing advocacy positions on any issues. But if people want to develop advocacy positions on a particular question, we provide legal support to those advocacy positions. For example, you might ask, if a school management committee has not been constituted in a particular district, what do we do? How do we get school management committees constituted? And what we try and do is we tell you that under the statute, these are the things that you do. And this can become an advocacy platform on which an entire initiative is built to get school management committees constituted. So we provide you with just the basic legal and technical information about whose obligation it is to constitute, what are the obligations under your state and under the state rules, and where you would go to get it enforced. Right? So that's what we mean by research and advocacy support. We also believe that there's no way we're going to get anywhere with the RTE legislation unless we know where it is working and where it is failing. So unless we have baseline data starting from 2013 in your respective districts and your respective institutes, where you know it, and it might be sample surveys, I'm not saying comprehensive surveys. Unless we know what that baseline information is and we're able to track to what extent RTE has been implemented or not been implemented, I don't think we can get any help from the legal entitlements which have been created under the RTE Act. The third thing is that if all else fails, if all the advocacy that you do in the executive branch of government fails, then the foundation should be willing to undertake legal action. Now, what legal action should we litigate in our own name? Should we allow and assist school management committees to litigate in different states? These are all open questions of how do you develop a legal strategy to get this act enforced. But I don't see, and as Rohit mentioned, and I second that view, which is that if all of the world were nice and we were all well-intentioned people, fully dedicated to the achievement of social goal, then we wouldn't need this legislation at all. So I don't see how the education right is going to be satisfied without some forms of mediated conflict. If you think that this is going to happen just because a new statute has come, that's certainly not a view that we share. So we need to think well ahead of time what our legal strategy must be. How do we get enforcement to happen, at least in the 5 states that we act in? Now, that's as much as I want to say in this part, and I think I've kept to my time, well in time. So I have a second presentation on the rules, what has happened in the 5 states that many of you are from, and also talking about the institutions that will need to be activated to get this legislation implemented. But let me say, I just want to close with one idea which I'm slowly losing track of, which I wanted to frame for you as a sort of framing question behind this presentation, which is, what did I want to do? Maybe it'll come to me as you have questions. I'll come back. I just had a thought about how we think about legislations like this in social action. Yeah, sorry, I know what I wanted to say. I think that underwriting all this is that I'm sure all of you have some model of social change in your minds. I don't know what your chosen or preferred view on why societies change and how societies change, right? But I'm sure that most of us sitting in this room have some intuitions about this. We have some views. And I think it's very important when we think about engaging with legal and governance systems that we interrogate what our idea of social change is. Because unless we know what part we play in this institutional arena, I don't think good intentions are enough. That's my view. I don't think that the foundation or the university will do its job just by having nice people in the foundation, who are all very nice and honest and talk politely and engage with the government in a very dignified and respectful way, and work with people. All very nice things, none of which is disagreeable, but I don't think it's going to get the work done. And so my sense is that ultimately people in this room and people who run these institutions have to decide what their model of social change is about. Why is it that all of us sitting in this room, aided by this legislation, if at all, can we make a difference? If so, what strategy might make a difference? I think that's a useful question to ask, assuming that everyone is similarly minded and well-intentioned. Right? Yeah, that's as much as I have. Thank you. I'll take questions maybe for about 5-10 minutes.
One request to you, and can you share your presentation to everyone?
Yes,
me or anyone, so that it could be.
We can just mail it to you
okay.
now. That's not a problem.
I have a couple of questions. Just let me take one. So. Presently, the state government are in compliance mode of complying Supreme Court judgment. Supreme Court is looking state government on 7 indicators only. You if you see, yeah. So on 9 indicators, but for 2 indicators, they said that if the land is not available, how a school can create a playground. So the state government are now in a mode to comply only those 7 indicators of RTE, toilet and room and all these things. Those infrastructure kind of things. So that is one part. It's not sure or something like that, but as Supreme Court dictates state earlier, provide midday meal scheme, midday meal to every child in the school. So it is going in that similar direction of as things were things gone and past. Maybe I'm little confused on this part.
So, can I just have a quick response? The first thing is that I just made an offhand comment as I was discussing the Supreme Court's views on the right to education, and if you picked up the tenor of that comment, I am utterly skeptical of the Supreme Court having any impact on these questions. I think the best we can hope for from the court is that it doesn't do any damage. So I don't think that the court in any sense is a useful social lead on these questions. So having said that, the priorities that state governments choose may be defined by many things, including Supreme Court judgments. I don't think that that's so important. Right now, you have a statute, and the statute mandates some basic entitlements. I think you have to decide what your priorities are and build advocacy platforms, knowledge, and engagement with institutions to enforce the statute. You use the courts. The courts are not an agenda-setting institution, and they should not be an agenda-setting institution. They're not very good at that. What they're useful at is if you set the agenda. Let's take an issue. I don't know what you might consider to be the, sort of the key pressure points for securing a good education under the RTE. Maybe the key pressure points are parent-teacher ratio. I'm just taking one example. Now, the statute mandates a parent-teacher ratio. Is the parent-teacher ratio satisfied? If it's not, do you have the information to show that it is not satisfied? And if it is not satisfied, can you take this to court and get it enforced?
Pupil teacher ratio, parent teacher ratio.
Sorry, pupil teacher ratio. Sorry about that.
But I mean, this is one opening, that parent teacher ratio. I mean,
pupil teacher.
ऐसा कुछ फ्यूचर में कभी होना चाहिए कि पेरेंट्स और टीचर का भी कोई
ratio. The only parent teacher ratio that I am aware of is in the school management committee. Yeah. But I'm saying that in that sense, you set those priorities. Yes.
और मुझे लगता है कि
या प्लीज
कि जो इससे पहले बात हुई थी ना कि जो इसके अंदर जितने भी प्रॉब्लम, ये तो सवाल है ही, इसमें प्री स्कूल का छूट गया और आगे का नहीं किया, और कुछ इसके अंदर जो फ्रेमवर्क है केंद्रीय कानून का, उसके बाद राजीव ने कुछ समझा, मगर जो सबसे ज़्यादा जिस पर ध्यान देने की ज़रूरत शायद मेरे विचार से लगती है कि इसमें जो चीज़ें कही गई उसकी सही व्याख्या कैसे करें और उस व्याख्याओं के अनुरूप राज्यों को जिस तरीके की व्यवस्थाएं बनानी, उसके ऊपर बात करना बहुत लाजिमी लगता है। जैसे जो है अब इसमें कहा गया कि भाई SCERT आपका एकेडमिक अथॉरिटी होगा, तो SCERT जो है राज्य की शिक्षा की गुणवत्ता के लिए कुछ करेगा, मगर क्या करेगा वो कंफ्यूज है, उसको न पहले करता था ना अभी कुछ करने का है। तो इसमें हम किस तरीके से मदद करें? अब जैसे उसमें कहा गया कि भाई इवेल्युएशन जो होगा कंटिन्यू और कम्प्रिहेंसिव होगा, मगर कैसे उसकी व्यवस्था होगी यह है। जैसे क्वालिटी एजुकेशन है जो अभी सब कह रहे थे कि उसकी सही व्याख्या क्या है क्वालिटी एजुकेशन। राज्य जिसमें सबसे ज़्यादा कंसर्न है वो है इंफ्रास्ट्रक्चर। वो उनके समझ में आता है कि इंफ्रास्ट्रक्चर देना है तो उसमें क्या क्या चीज़ें होंगी, उसके लिए उन्होंने खटाखट व्यवस्था भी बना ली। पर जो सवाल इसके हैं, जैसे शिक्षक को 45 घंटे सप्ताह में पढ़ाना है तो उसका शेड्यूल क्या होगा, क्या बात करेगा वो?
So I'll say two things. First is that there's a reason that states are very interested in infrastructure, because it fits right into the political economy of a contractor-driven state. So this is another contract in which central funds are given, so they can do what they want. So states are very happy with an infrastructure-driven RTE agenda. So I don't see any. I mean, one doesn't have to think too hard why states are only interested in infrastructure. It's quite easy to understand. The second thing I'd say is that it is no statute can specify in every detail what must be done, say on a question like curriculum and syllabus or teaching pedagogy. It is not the job of Right to Education Act. Finland's Right to Education Act doesn't say what must be taught or who must teach and how much. And Finland has the best education system in the world by most metrics. So if you want to then say how do you get quality education, I think there's a lot of hard work. The hard work is to find out what you think is the best model for how an SCERT must function, to track how the SCERT functions, and to enforce a better performance. That is the job of those who look from the outside at state institutions. Right? So I don't think that any of these issues can become issues of implementation which can be priority areas. But I think it's important to know what are your priority areas. You can't chase every issue. You can't chase toilets, midday meal scheme, pupil-teacher ratio, level of SCERT, curriculum setting. You can't do everything. You must decide that for a few years, you will focus on 5 issues or 3 issues. Why? Because you think that those 3 issues are more important than anything else. If those 3 issues are achieved in a 5-year cycle, not achieved fully, I don't imagine 100% achievement on any parameter, but even achieved, if you move it from 40% to 75%, you have achieved a significant improvement in public education. That is the value of a statutory framework. Not because the statute tells you what you must do on syllabus or curriculum, but it gives you the opportunity to say for yourself, this is what we must do. And then you advocate that position. You advocate that position with government, you advocate it with civil society, advocate it with the parents, and let that demand for that quality emerge. And take it to courts, take it to the implementation institutions within the RTE, and you might build momentum around 3 or 5 critical priority areas in the RTE. That's what I think an implementation agenda must look like. Yes?
In case of AP, so Government of India passed an act in 2009, April 1st. But in case of AP, the AP has drafted its own rules in 2010, and within the rules, the implementation authority has been given to SSA. Interestingly, I don't think other states have done that. After SSA doing that, they made 3 things. One is that this 25% only after filling seats in public schools, 25% will be applicable to private schools if there is no vacancy in the government schools. That is one thing. Number 2, within the 25% reservation, they made sub-reservations, say 5% SC, 6% ST, OBC, minority, physically handicapped. They divided. And then, till now, best of my knowledge, no child has gone to private school under RTE in 25% quota. And again, some people, as you mentioned, private school body went to High Court of Andhra Pradesh and issued a petition saying that government is forcing private schools to take up the students without paying any fees. That so it is illegal, as mentioned other cases like that. And High Court of Andhra Pradesh issued a notice to the state government saying that reservation within the reservation is illegal, so it is not applicable. As reservation SC, ST, BC, OC, minorities and physically handicapped like that 25%, that reservation is not, hence this act will not be implemented in the government of AP or in the state of AP like that. Again, that case went to Supreme Court. Now status of Andhra Pradesh RTE is in the hands of Supreme Court.
Yes.
This is what the status.
Okay, so I'll say 2 things about this. One is that it's very useful for us to document different state practices, and which we are already doing. For example, the idea that you spoke about disadvantaged 25% being divided among various beneficiaries is an issue that we have studied. Clearly, Andhra Pradesh has done it in the most elaborate way, more than any other states. It's very useful for different field institutes and different state institutes to look at what other states are doing, because these become templates for achieving the objectives of the RTE. Some states may do better than others. In our next session, we will look at some of these examples. Just give me a second. On the issue of the Supreme Court view on subclassification of the disadvantaged groups in the RTE. Thank you for bringing it to our notice, because we didn't notice that. And if one thing is that if you think that the foundation can play an important role in shaping the way the subclassification debate goes, we should intervene. We should intervene in that litigation and argue a position that we think, from whatever empirical evidence we are aware of and what we are aware of with field practice, that this is the best position to take. We should intervene. So I feel that it's only with that kind of intense engagement with the RTE process that any good will come, if at all.
Recently, I had an interaction with SPD of SSA AP, who is in charge of implementation of RTE. She mentioned very clearly that MHRD has interpreted this act in different way and they made wrong act. So we are doing correct. She mentioned that act was made wrongly, but we are interpreting it in a right way and we are implementing the spirit of act, saying that this 25% has further divided for all the groups, like that she mentioned. Other thing is,
I don't think that
it's a
whatever her views might be, that it's going to count for much.
Yeah. Other thing is, we have been, especially Azim Premji Foundation in Andhra Pradesh, we have been doing research in private and public schools since 2007. In view of RTE and 25%. And we started in 2007, it came in 2009. That time we thought that this 25% would be applicable for all primary classes, and we designed the study in such a way that children who had disadvantaged background and experience in government schools, especially in class 0, which means everybody and 1 will go to the private school and they will study for class 5 or 5 years, and they can experience and see whether it will be relevant to the RTE if RTE comes into existence. So we have that findings and we will share it.
Are there any other questions or comments on what we've said so far? Yes.
थोड़ा सा ये जो आंध्र प्रदेश की उत्तराखंड से बिलोंग करता हूँ, उत्तराखंड के परिप्रेक्ष्य में हम देखते हैं, जो बात आप कह रहे थे कि हमारा जो रोल है इम्प्लीमेंटेशन में या फिर उस प्रोसेस में, मुझे एक चीज बड़े उस दिशा में दिखता है कि सर्व शिक्षा अभियान को ही ये जो RTE एक्ट को इम्प्लीमेंट करने की जो एजेंसी बना दी गई है, तो एक तो मुझे गड़बड़ ये गड़बड़ क्या मतलब इसमें बड़ी चालाकी दिखती है, ठीक। उसका रीजन ये लगता है मुझे, मतलब जो गड़बड़ दिखती है वो ये दिखती है कि सर्व शिक्षा अभियान किसी भी स्टेट में उसका एग्जिस्टेंस जो है एक यूँ समझिए आपकी संस्था के तौर पे है ना। ऐसे को जैसे उत्तराखंड में सभी के लिए शिक्षा परिषद हो गया, जिस दिन SSA ने या कहीं से कोई फंड बंद हो गया तो उस दिन ये संस्था भी, इसमें जो भी काम करने वाले लोग हैं वो सिस्टम से हैं। कुछ राज्यों में आपने कॉन्ट्रैक्चुअल रखे हैं, जो उसका हेड है वो सीधे एक्स ऑफिसियो है, फुल फ्लेज्ड ऑफिसर है। तो एक तो मुझे उसकी मंशा पे वास्ता करता है। उत्तराखंड में इतने मतलब कम से कम 25 जियो निकल गए, आपका 25% का सबसे पहले ऐसे का रिजल्ट होगा। ये जो आप कह रहे थे कि किसी और राज्य में नहीं हुआ होगा, सब राज्यों में हुआ है। 25% जो उनका कैटेगरी क्या होगी, कितना % किस कैटेगरी को होगा, वो सब जगह है। हमारे यहाँ भी खूब ये 30-35 पेज का एक निकला हुआ जियो या SCRT। अब मैं अपनी भूमिका को जो देखता हूँ, ये तो सरकार या सरकारी सिस्टम की अपनी चालाकी हो सकती है या फिर क्या हो सकता है। अपनी भूमिका को मैं इस तरीके से देखता हूँ कि हम RTE के इम्प्लीमेंटेशन में सरकार की मदद कर पा रहे हैं या सरकार के साथ जो भूमिका निभा रहे हैं वो किस तरीके से निभाई जा सकती है, और उसको इंस्टीट्यूशनलाइज करना सबसे बड़ी बात मुझे ये लगती उसको आप जो है इंस्टीट्यूशनलाइज कैसे कर पाएंगे। उदाहरण के लिए हमने कैसे शुरू किया था, जो हम उसको देख रहे हैं कि शिक्षक भर्ती की बात करता है ना, आरटीई में कुछ अध्यापकों के लिए कुछ नॉर्म्स हैं, सारी चीजें हैं कि एक अध्यापक की पात्रता क्या होगा। तो पात्रता तो आपका एनसीटी फिक्स कर रहा है कि इस तरीके के हो, उसको हम जाकर के केंद्र सरकार को बोलती है कि आप इसको ऐसे लागू करो। राज्य में जब वो पहुंचता है तो राज्य के अपने पॉलिटिकल उसमें बहुत सारे छेद हैं। मसलन जो है कि आपके पैरा टीचर्स हैं, शिक्षा मित्र हैं, शिक्षा बंधु हैं, शिक्षक साथ जो भी हैं, उसने इंटरमीडिएट किया, पिछले 10 वर्षों से राज्य के अंदर वो अध्यापक हैं प्राथमिक शिक्षा में। अचानक आरटीई आता है और सरकार नहीं बोलती है, वो सर्व शिक्षा अभियान बोलता है कि भाई हमारे विद्यालयों में तो अध्यापकों की भर्ती इस नॉर्म्स पे होनी है कि उसका ग्रेजुएट होना चाहिए, वो टीईटी पास होना चाहिए, वो 2 वर्ष का डीएलएड या डीपीएड या बीटीसी जो भी हो वो होना चाहिए। दूसरी तरफ सरकार बोलती, जो सरकार है, एजुकेशन सेक्रेटरी है, तुम्हारा एजुकेशन मिनिस्ट्री है, उसको इस नॉर्म से कोई लेना देना नहीं, वो अपना पॉलिटिकल जो उसको फायदा लेना है उसमें कुछ ना कुछ जो वो करके उन लोगों को जो है कि भाई ठीक है, आज तुम्हारा 3000 का मानदेय बढ़ा दिया गया, 10,000 था आज 13,000 कर दिया, है ना। आप जो है शॉर्ट टर्म उसको उस पे जिसको कहते हैं कि टल्ले लगाते जा रहे हैं, और इसके इम्प्लीमेंटेशन में इतनी बड़ी बाधा वो बन रही है कि अब एसएसए तो कह रहा है कि सब स्कूल भी खोलेंगे तो टीचर की भर्ती इस नॉर्म्स में होनी है। आप उस नॉर्म से एसएसए के आरटीई के नॉर्म से भर्ती करते हैं तो उधर शिक्षक मित्र शिक्षक बंधु कहते हैं पहला अधिकार तो हमारा है, हम 10 वर्षों से ये सब कर रहे हैं, ठीक है ना। तो एक तो सरकारों की ये चालाकी और ये जो पॉलिटिकल विलिंग वाला मामला है, मुझे इसमें लगता है कि हमको हमारा जो अपना जो मदद वाला जो मुद्दा है वो एससीईआरटी से शुरू होता है। इस साल हमने कोशिश ये की थी कि उदाहरण के लिए एक तरफ आरटीई जो है, आरटीई इम्प्लीमेंटेशन एजेंसी तुम्हारी एसएसए है, लेकिन एससीईआरटी और एसएसए के बीच में कभी मेल मिलाप नहीं पिछले 10 वर्ष। किन्हीं राज्यों में होगा, सब जगह तो मुझे लगता नहीं है, कुछ राज्यों में हो सकता है, लेकिन अधिकांश राज्यों में वो मेल है ही नहीं, वो जो अलाइनमेंट है। तो आप न तो पाठ्यक्रम के लिए एससीईआरटी को पूछते हैं, ना आप जो है असेसमेंट के लिए पूछते हैं, ना आप पाठ्य पुस्तकों के लिए पूछते हैं। आपकी अगर फ्री टेक्स्ट बुक डेवलपमेंट हो रहा है तो उसमें एससीईआरटी का कितना हाथ रहता है मुझे जानकारी नहीं बाकी राज्यों की, लेकिन उत्तराखंड में तो स्थिति कुछ दूसरे किस्म की। तो अब इन दोनों को एक साथ लाना, और इन दोनों को एक साथ लाने के लिए हमको मुझे लगता है कि वो आरटीई का जो जिसको हम कह रहे हैं कि आरटीई एक मुद्दा हो सकता है, उसको तो आप छोड़ दें। हम ये कह रहे हैं कि प्रोसेस में ये कैसे आए, और जब ये प्रोसेस में आते हैं मिल करके तो तब कुछ संभावना बढ़ती है हमारी कि हम एससीईआरटी को जो है एकेडमिक अथॉरिटी को एहसास करवाएं कि आपका काम ये है। उदाहरण के लिए हमने जो अभी AWPB वार्षिक कार्य योजना बजट राज्य की बनती है, तो ये कोशिश की है कि ये पूरी तरीके से एससीईआरटी इसको लीड करे।
Or I'll just come to that. I'll respond to that comment in 2 or 3 slightly different ways, and I think probably I should finish, right? Because you're roughly on time. I mean, you're 10 minutes late. So I'll respond to your comment in 3 different ways. First is your choice of institutions. I don't take the comment that you made to be critical of the Sarva Shiksha Abhiyan, because I'm neutral as to choice of institutional forms. I'm interested in institutional forms that are accountable, that are legitimate, and that deliver. And these are just give me a second. Can I'll listen very patiently. So I'll just bear me out on this. The choice of a mission mode for the delivery of education was because of the profoundness of failure of state institutions. That's the first thing that one needs to understand. Why a mission mode of delivery? Because in the late 1960s, Jawaharlal Nehru had a problem, which was to tackle the space program. And he knew that even if he gave $2 billion to the Department of Science and Technology and gave them 30 years, they would not launch a satellite, far less anything else. It was just impossible because of certain structures of government. right? So he developed the mission mode idea of institutional architecture. It has now become the chosen mode for the central government to intervene in any sphere of public life, whether it's the National Literacy Mission or whether it is the education Sarva Shiksha Abhiyan. So, is the mission mode a perfect answer? Maybe not. In various ways, it is not a perfect answer. Has it done better than the existing modes? And the answer has to be a qualified yes. So I'm not willing to go with the general celebration of the SCRT. I'll be very frank with you. So we have to think very hard and clearly about institutional choices, which institutions deliver, which institutions are worthy of respect and engagement, which institutions should go. And those are situated choices, right? The same applies to the question of para-teachers in the NCTE qualifications question. The way I look at it, I don't know the data to be able to say that para-teachers are, I can intuitively get the idea that para-teachers are better than no teachers at all. But should para-teachers have the first right on education jobs as opposed to fully qualified, whatever the value of that qualification? And I know that NCTE qualifications may not be that great anyway. So there's a question. These are deeply empirical and situated questions. And frankly, I don't see from my vantage point that I need to take a view on it, but you need to take a view on it. And the people who do this engagement, who understand the empirics of these problems in detail, must develop a fully considered view. Do you want fully qualified teachers, or do you want a para-teacher administered education system? For me, personally, I am not invested in that question. As a law, I'm interested in institutional structures, and I'm interested in the legal ability to get things done. What position one must take on the para-teachers question is an issue that many of you in this room are well qualified to think through and decide. And if the foundation develops a position that we will push for one or the other, then we should push for it. But I think it's important that we decide, as opposed to talking about it. And really, what I'll close my last comment with the idea that what's interesting about thinking and working in areas of Indian law and policy is that social elites, and I include all of us in the room as social elites, because given the general demographic breakdown of our country's population, all of us who've got primary, secondary and tertiary education are invariably social elites, okay? Is that social elites in India are very, very morally exercised on big debates. Very, very, when RTE Act is being passed, there is all sorts of protests against some portions of it, great moral exertions about how this or that is wrong about the RTE Act or right about the RTE Act. And also we are very, very taken up with Supreme Court decisions. So when it was in the Supreme Court, there was this great chorus of interest in the RTE. What is spectacular in this country, in our public history with institutions, is that nobody is interested in the details of how you get something done. When the great moral questions have somehow been settled in legislatures and in the courts, then no one puts up their hand to say, yeah, we will do this now for the next 10 years to get the nitty-gritty of this institutional architecture working. That is the toughest job. Bureaucrats who are also social elites have no time for that. Some may say they're not even qualified to do that, you know, the general bureaucracy in the country. The people who occupy public office, bureaucracies, and I'm talking now about DEOs and BOs, also have no time for that. Because they are engaged in other personal projects, which are far more important to their everyday existence than the tasks that are supposedly immediate and pressing for them. And I think that, at least from my perspective, my great interest in the RTE, or for example, what's going to come in the area of health, is to see whether this country, whether we are able to do something differently, whether we are actually able to take care of the details. How exactly do we create institutional architectures that work? And for me, this is both a personal as well as an intellectual concern. I think that this is the greatest challenge. The big moral question, what should the relative authority of the state be versus parental authority over children, it's an important question. It's a question that we must think about and study. But really the pressing question is, can we actually get public education in this country to improve from whatever baseline we have at the moment by about 30 to 40% in 5 years? Is that a meaningful, realistic possibility? That is the question that we all need to ask with complete seriousness. You know? And I think if we are able to do that and play some part, I'm saying the we here is the foundation, if we are able to play some part in that process, in the details, then I think we've done our job really well. And I hope that part of these discussions is about creating that possibility. You know, that the foundation can participate in that possibility. The big questions apart. That's as much as I want to say, Pradeep.
So can we break for lunch?
Yeah.
हिंदी में समझ लेते हैं, लेकिन थोड़ा उनको बोलने में मुश्किल है। तो एक रिक्वेस्ट थी कि जो अगला सेशन उनका होगा, कोई साथी उसके बाद उसको 5 मिनट में या 2-3 मिनट में सम अप कर होंगे। तो रंजना बोलिए। तो रंजना और खजान भाई अगर आप भी, तो 2 लोग थोड़ा इस दृष्टि से देखें कि सेशन एंड होने के बाद में उसको 2-3 मिनट में हिंदी में सम अप कर तो ठीक है। और
Thank you, and thanks for being back for the second session. So in the first session we looked at the Act and the Supreme Court judgment on this question of education. In this session we look at rules and institutions. I mean, it's obvious to all of us who work in these areas that passing an act is only one part of implementing any policy. In some ways, though it seems increasingly difficult in India's parliament at the moment, passing a legislation is generally the easier part. Implementing legislation is a far more difficult and complex activity with a range of actors. The Right to Education Act anticipates this difficulty. So in section 6 of the Right to Education Act, it says that the state government shall make rules for the implementation of this act, but with a period of 3 years. The period of 3 years starts from 2009, from the date of this legislation taking effect. Right? Period of 3 years will take us into 2012. Most states interpreted this to mean 2013. That is academic year 2013. Some states have already made rules and implemented in 2012, but a majority of states, really the first year of national implementation is 2013. June, July, start of the academic. So in this presentation what we look at is we'll just broadly survey some of the issues in the rules, in various state rules. We'll tell you what the range of variation is. Also, maybe you have experience in rule making and rule implementation. We'll highlight some issues of difficulty. And the second half of the presentation deals with institutions. And we try and sketch out the range of institutions involved to implement different portions of the Act and how you can work with these institutions to get this done. So let's start with the structure of the implementation of an Act. So right at the top we have the RTE Act, and we should actually add in the slide that section 6 gives 3 years time. Then you have under section 38 of the Act you have state rules. Now the rules are on the widest range of subjects. I have just put a few subjects up. School establishment and recognition is one subject. Reservation and compensation is another subject. Regulating teachers, their training, their recruitment, their salaries is another subject on which states can make rules. Now once you make rules also, the story is not over. What do the rules do? They take the issues under the Act and give it more detail. Having said that, someone still has to do the job. That job is down to institutions. The creation of institutions and the implementation of the rules. Right? So if you look at it in this tiered fashion, you get a sense of how debates are connected. Debates about provisions of the Act are connected to debates about particular rules. Are rules valid as per the Act? Is a very important and relevant question for every state institute. If you find that the rules themselves are invalid vis-a-vis the Act, you must challenge those rules, especially if those rules are on an important area of RTE implementation. Then you have state practice through notifications and circulars. Now, are the notifications and circulars in compliance with the rules and then in compliance with the Act? Is your next range of questions. You must always look, if you find a circular or a notification that you do not find agreeable, the first question you must ask is, are they in compliance with the rules? If they are in compliance with the rules, is it in compliance with the rest of the Act? Right? So these are important questions that you will ask as you begin the analysis of implementing the RTE Act. Right? We compare state rules on a few questions. And let me just start with the issue of defining disadvantage. Now, as you can see, if you just look at the slide, you get a sense of the range of definition. So we have actually put up only the more elaborate ones. So if you notice, Andhra Pradesh has an elaborate definition, but so too do Karnataka and Uttarakhand. Rajasthan and Chhattisgarh, Rajasthan has a modest definition. In Chhattisgarh, Puducherry, there is no definition at all at the moment. They may issue a further circular, but in the main rules there is no definition of disadvantage. Now, definition of disadvantage, just to be clear, does not have to come from the state government, because you can also leave it to the schools to decide what is a disadvantage. The state government doesn't have to decide. In fact, the Act does not mandatorily require state government to decide disadvantage. Now, one of the problems in the way state governments operate, and generally public policy operates in India on this question, is everything is thought in terms of reservation. So we go back to the same reservation quotas and you replicate them, like Andhra Pradesh. Andhra Pradesh is your best example. You replicate what is there in the reservation quotas with some slight modifications. But just imagine for a minute that schools adopt definitions of disadvantage that are locally relevant. For example, in an area where there is a natural disaster, the school may use as a definition of disadvantage families that are affected by the natural disaster. That might only apply within one district, but it might be a very relevant criteria. But the way we do disadvantage in this country is always to use the same SC, ST, OBC, disability, gender, and you usually add one or two others, and that's how disadvantage is talked about. Incidentally, schools, private school managements, at least in South India, are pushing very hard that they should define disadvantage in their respective areas. For example, some of them want to use single mothers as a very important indicator of disadvantage for children. It might be useful, it might be socially impactful if we allow that to happen, but it looks unlikely that that will become the standard. But it's useful to ask in your respective states, especially, I don't know whether anyone from Chhattisgarh, Puducherry are here, whether pushing for a definition of disadvantage is a useful strategy. The second thing that we're looking at, where we move now from duties of, we're looking at duties of the state, we're looking at two other questions. How do you define neighborhood schools? And how do you grant or withdraw recognition of private schools? And what you notice from neighborhood schools is that you can get all the way from 1 kilometer, 3 kilometers to 5 kilometers to the use of a population criteria. You can say a population area, depending on population density, you can define an area of what constitutes a neighborhood school. Why is that important? Because in a neighborhood school, you cannot be denied admission. And if you look the world over, as a public school system evolves, geography becomes very important. Because some public schools will be better than others, and then everyone wants to get into that public school. Then if the defining criteria is what is the neighborhood, then either your distance criteria or your population density criteria becomes critical. Today, there is no great pressure and no great differentiation between in the public school system. So this neighborhood definition might look innocuous. But in the years to come, if the public school system develops and is competitive with the private school system, then neighborhood definition will become a very serious question. And each of these zoning has differential impacts, and it's worth studying. Grant and withdrawal of recognition. Now, some people, even in the lunch break, have come and asked me this question about who is deciding recognition now. And so let me just clarify this to you and explain it a little bit. Which is to say that in some states, the Commissioner of Public Instruction is the implementing authority for the RTE. That person is usually, that officer is usually the authority under the State Education Act as well. In cases like that, all recognition under the state law as well as recognition under the RTE rules will be administered by one person. In states where the authority under the RTE has been given to some other authority, like the Sarva Shiksha Abhiyan or some other mission agency, then that mission agency may be the recognizing authority. So you must check in your states who is the recognition authority and what rules they are applying and how will this work. Now you can think of all sorts of problems where you are recognized under one authority and not recognized under another, which is a good question, and I think this will only be sorted out in the months and years to come. What you notice though is your recognition criteria can change. Some states are insisting that compliance with RTE 25% is a part of the recognition criteria for the school. Other states are not insisting on that. Other states are insisting that if you satisfy the general requirements of the schedule and the old requirements under the, say, Karnataka Education Act, if you satisfy that, then that's enough. So you must look on a state-by-state basis what is the criteria for recognition when you think about schools. No state has provided for recognition of government schools. This is a very important question as we flagged for you, because there is no guarantee that the public school system will improve unless there is some external pressure that it improves in this way. Now what we notice is that quality of education as a subject matter of the rules is patchy. Most rules say nothing about quality of education. What we find interesting is the state of Uttarakhand has monitoring and policy and learning outcomes monitoring and policy assessment built into the rules. Now you might say, but how will it be enforced? I think if that information becomes public information in the first instance, that is itself a very significant outcome. And Uttarakhand provides for that. Puducherry has a different approach. It allows for grading and ranking of schools. So you will get a segregated school system saying which school is performing at which level within the public school system. Other states don't have any mention. States like Karnataka have no mention, best of our knowledge, Rajasthan as well, no mention of quality of education parameters in the rules. Now, duties of schools. As I said to you, we divide it up into different kinds of duties and methods of enforcement. So, the duties of schools are actually among the lighter things in the Act, but the two main issues are the 25% disadvantaged question and the learning outcomes question. And frankly, I have not looked at these this segment of the rules in considerable detail, so I don't want to get into it. But you get a general sense from the slide that the duties on schools, the primary duties on schools are actually the 25% disadvantage, the administering of the 25% disadvantage. The other things are quite light by my by myself, but I'll let Dolush correct. Is there something on the slide that you highlight, especially on the second, quality of education?
Well, if you actually look at what Uttarakhand does in terms of academic monitoring and how it provides a system within, the education department to provide support to teachers, and also I think head teachers in every school are. I think the Uttarakhand team should also correct me if I'm wrong here. Are responsible for achieving learning outcomes and things like that, and that sort of aggregates into the DEO's duties to the BEO's duties and things like that.
So that's interesting. At least the if that understanding is correct, then the Uttarakhand rules integrate the existing education bureaucracy into the implementation of the RTE, which is a very useful strategy for other states to follow. With the teachers' duties, nothing more elaborate than what's in the Act. Already, I think most teacher institutions are complaining that the Act imposes too many duties on teachers. There is no specific mention in the rules about levels of training and recruitment for teachers. So this whole teacher training and educational qualification not mentioned in the rules, though we all know that these are important questions in the way teacher recruitment will operate. Okay, now compensation is another question. Now some private schools have demanded that compensation for this 25% should be administered by committees that are partly private school managements and partly government, so that there is a fair calculation of costs and compensation. So some states have done that. Most states have just basically deferred to the usual bureaucratic structure, which will be the DDPI or some other structure to decide. School management committees, the structure and appointment of the school management committee is left to the school, but rules can specify how such a committee should be constituted and how it should be operationalized. Some states have made rules which divide up the school management committee between the general membership or a general council and a smaller body, an executive council, which manages the everyday issues that crop up in a school. I frankly, I have not read any literature saying that one is better than the other, but if there is some experience on this, then that can become an advocacy point where you push for a particular structure of a school management committee because something actually works or doesn't work. If you have evidence and you have a field practice on this question, then the design of SMC will become an important issue. Should SMCs handle teacher grievances in the state of Karnataka? That option is open. Now in some other states that doesn't exist. Okay, if you get this elaborate body of rules, how do you implement it? And the way you think about a statute like this is that there are two broad ways. There are mechanisms internal to the statute and there are mechanisms external to the statute. Okay, so you have to, the choice of mechanism, who you approach and how you approach, depends on the range of issues and the degree of escalation. Right? In the first instance, you might use internal mechanisms. If they fail, you must know where to go if the internal mechanism fails. So what are the two internal mechanisms available? The first internal mechanism is the local authority. Now who is the local authority differs from state to state, but it usually includes your entire education bureaucracy, the DEOs, BEOs and the whole structure, all the way up to the Commissioner of Public Instruction or whatever Deputy Director of Public Instruction, whoever that officer is, all the way up to the Principal Secretary of Education. So that is one internal structure that's available to you. In some other states, the local authority might be a Sarva Shiksha Abhiyan related agency and its affiliates down to the district. Usually, even in those states, the Sarva Shiksha Abhiyan authorities and the education bureaucracy are sitting in the same place, best to my understanding. I don't know whether they have different offices and they're actually disaggregated, but to best my understanding, they're actually sitting in more or less the same spaces, but technically there might be two different agencies involved. So this local authority, you need to figure out who that is in your respective state, and they are, for many of the obligations, your first port of call. That if something is not working, you work with them to get it done. The parents participating in a school management committee are capable of doing a range of everyday elements of school education. They have the power to change. So in this case, the advocacy initiative is on a school-by-school basis. So if you have in-depth information and knowledge about how a particular school is working, and you want to change something in a particular school, then the way to do it is by engagement at the school management committee level. It might well be a useful strategy that you work with parent groups all over your field area to make sure that all the school management committees are thriving. So if you're able to do that, you might have a very effective lever to change education practice, bureaucratic practice, using the school management committee. These are the two internal mechanisms in the Act, right? So the Act allows for these two mechanisms as your to push your agenda change. Now, if you go outside of the education bureaucracy, the Act provides one external check. And the external check is the state and national child protection committees. Now, which body gets authorized as your state or national, as your state child protection committees depends on state to state. You must check your rules and notifications to see which body has been named as your grievance redressal mechanism. Now, it's very important that you build up a practice of using the grievance redressal mechanism. Because if you don't use the grievance redressal mechanism, the standard complaint is, if we have set up all these bodies and nobody comes to them. But if you come to those grievance redressal bodies, put pressure on them to act, and they still fail to act, you will develop a very effective paper trail that can be useful in litigation. If you don't have that paper trail and you don't have the capacity to utilize these institutions, then very unlikely that you can go to court straight away and get useful relief. If this fails, if the grievance redressal mechanism fails, then you have no option but to go to court. And the first court, the court that you would go to is your respective state high courts. But I would say that the only useful litigation in these cases is if you get a wide body of practice. The only good reason to go to court is not to change the practice of one school. You must have intervened in a particular way in 25 schools and shown that in all 25 schools something has not changed, which is mandated by the Act. Second, that you have gone to the grievance redressal mechanism. Grievance redressal mechanism is not able to address the grievance or has not given you a remedy in a reasonable period of time. Then you take the 25 schools cases all together up to the High Court, and the High Court will be inclined to change the policy itself. And because the writ jurisdiction is a discretionary, the court has discretionary remedies, it can order the change of a policy itself. It does not need to go back to the education bureaucracy to say, you consider this. If you can show that a particular strategy, I don't know what your priority area might be, but maybe like I just mentioned one, pupil-teacher ratios. If pupil-teacher ratios is a very good proxy for learning outcomes, then if you just show that pupil-teacher ratio has not been achieved in a reasonable period of time, the court can well order that pupil-teacher ratios of particular thing have to be achieved in a defined period of time, and that can be a revolutionary change, right? In these contexts. So, but I want to stress the sequencing of this effort, which is that you must start with the internal statutory mechanisms. You can't just decide that you want to raise some abstract issue in the High Court. You can, but that's the useless way to do litigation, right? That's only good to come in the papers for 2 days in some papers and maybe on news channels. It doesn't change anything. right? So if you want to change something, then it must be built on a practice of engagement with these institutions. So what are the next steps that we should take? Let me speak for what we at the RTE Hub are doing ourselves, and then on my next slide is really a blank slide to say what it is that you think we should do as interesting areas of work that we can start working on, or that you're already working on, that are worth doing in the next few years. The first thing that we feel is that whether it is for litigation or for even understanding the value of our interventions, this 2012 to 13 period, the next 6 months are very, very important, because the next 6 months allow you to establish baseline indicators on your priority areas, whatever your priority area is. Like if we take pupil-teacher ratio as your priority area, what is the pupil-teacher ratio in your field science? As of 2013 June, is very important to document, right? It's only if you have that can you show that the state is either improving or it is not implementing. So whatever your priorities areas are, please establish some baseline data before July 1st, 2013. That's the first thing that we will say. What we think is that it's very useful to either do quarterly studies or annual studies, half-yearly studies on the same 3, 4, 5 priority areas, so that foundation-wide we develop a metric of what we think is worth acting upon. If that would be a coherent strategy that everyone can, if everyone can agree upon, would be a very useful way of doing it. That's number one. We think that that's an important thing that we should prioritize. The second thing is, part of what we've been discussing is to clarify the content of the rules and their application. If we can develop a regular dialogue about new rules, notifications, circulars amongst ourselves as to what is happening in the individual states, then we will have the capacity to both clarify what is best practice across the nation and where advocacy by state teams can go. If there are some rules that we think are patently illegal, we should challenge them straight away. But if there are some rules that we think it could go this way or this way, and if we go the A way, it's a better way, then you all should develop advocacy, and we can help you develop the material for that. If, for example, if you think a particular definition of disadvantage is better than another definition of disadvantage, then we can marshal all the data of all the state rules so that you can go to your state bureaucrat and say, look, this is the data. Other states are doing this, you should also do this. So we can help you prepare, and that's the second thing we can do. We can help you develop clarity about the legal status in different states, help you build advocacy materials that you can use. We can't do the advocacy ourselves. We are a team of 3. So we can only help you build those materials. Once we build those materials, you can use it in any way that you want. The third thing that we think we should do is that we should develop strategies of engagement with institutions. We have to decide which institutions are important, which institutions are less important. Once you decide which of these institutions you want to engage with, then we have to try and learn from each other's work as to how we engage these institutions. Let's say we engage school management committees. We can very quickly develop a module on how a school management committee must be formed. For example, a school management committee has to adopt its own rules and its own form of administration. If we develop a template, standard rules, that school management committees can adopt, we can use those rules, translate it into all the relevant languages, and very quickly allow a school management committee to get set up. Otherwise, if you know, and I've spent a lot of time studying and working with government, school management committee rules will take 1 year, if not 2 years. Just the making of rules, forget about the meeting. To make the rules, they will take 2 years. So if you want to get over these kinds of hiccups, you can say the school management committee is the most important institution, so let us get involved there and make sure that they get set up and running. Just 1 second. But you might say that maybe school management committee is not important. Then in that case, you decide how you're going to strategize to engage the education bureaucracy. If you don't think the education bureaucracy is any good, then you think about the grievance redressal mechanism. If the grievance redressal mechanism doesn't do its work, then you think about the courts. But I think that in each of these cases, we can develop strategies of engagement that run across the foundation, and we can help you at least with the legal part as to how you engage. What are the obligations of each? For example, you go to a school management committee and it says, we can't do this. We can help you make the case that they should do it. Right? So this is useful, and it's a good way of us pulling together.
Can go to the previous slide. On point one, what SCPCR is doing nowadays, they have planned a study across India, and they are taking around 50 to 70 schools in each of the states to capture this baseline data. So in Uttarakhand, they have contacted us, and they also shared their questionnaire and all that. So they are trying to see things in urban district like Udham Singh Nagar, and one in maybe in Almora or in Nainital they will do. So Raghu of Almora, they are coordinating. So we also can talk to them, or we can engage ourselves with them. They have also requested कि क्या इसको तलाशी में कर सकते हैं. तो फिर मुझे लगा था कि ठीक है, हम दो जगह में उधम सिंह नगर में थोड़ी हेल्प कर सकते हैं. चंद्रा से शायद उन्होंने आपसे बात की होगी रघु ने. But NCPCR is doing that study across the country.
That's excellent, because
with the help of some Save the Children कहीं मदद कर रहा है, Plan कहीं मदद कर रहा है, Room Read कहीं मदद कर रहा है, इस तरह का. But yeah,
I should make it clear that we do not for a moment mean that you must do the field service. But I don't think you can proceed without having that data with you. In whatever your field of operation, you must have that baseline data at your disposal. If you don't have it, you don't have to do it. It might already be available. But you must get access to it, and it must form the basis of the strategy. So, I'll just conclude. So in this second section, what we've tried to do is to sketch for you the rules and the institutional framework that allow for an engagement with the implementation of the RTE. And what we're suggesting to you is that a good place to start, when I say start, you may already well have started with this process. But if you haven't, the good place to start is to engage seriously with the rules that have been framed for your state, develop baseline data that allows you to assess the implementation of the rules, and then hereafter develop a strategy of engagement with these institutions. From Azim Premji University, the law and governance team, we have a small group of people who will work on this issue for the next 3 years. So we intend to work on this in any case, right? So insofar as field institutes, state institutes, we find common ground, that these are the issues that we can focus on, then I think that a good synergy can be built around an overall foundation-wide strategy. That's it for me. Thank you. No, my next slide is actually an empty slide for you to make a list. I don't know, maybe you already have a foundation strategy and what your priorities on RTE implementation are. If you do, that would be very useful for us to list and to see, because for me then I take it home. Jolashri and Karthik, my colleagues, stay tomorrow, so they will listen to you tomorrow as well and see if you all can agree that there are some areas that you want to focus on, then we will focus on the same areas in our work, in our research. So you should tell us, really, if someone has ideas already, then we can start putting them up. If you think it will take a day and a half to develop the ideas, then we can sketch it at that time, tomorrow afternoon, this time. So, but are there any questions, comments, or you want to do the translation?
गड़बड़ बोलोगे तो बाकी भी ठीक कर लेंगे।
कोई बात नहीं, वो सबको स्वतंत्रता है। तो मैंने कोशिश की कि ये जो बोल रहे हैं उसको हिंदी में कैप्चर कर सकूं। हो सकता है कुछ चीज़ें मिस हो गई, तो मेरे ख्याल से सारे साथी इतनी अंग्रेजी तो समझ ही लेते हैं जो इन्होंने बोला है, वो कम्युनिकेट होता है। तो बात की शुरुआत सुधीर जी ने यहाँ से की थी कि RTE को बनाना और उसको बनाकर उसकी तरह प्रस्तुत करना जितना आसान था, उससे ज़्यादा कठिन इम्प्लीमेंटेशन है। और ये स्टेट की जवाबदारी दी गई है कि वो 3 साल के समय के भीतर इसको इम्प्लीमेंट करेंगे। इसकी डेडलाइन जो है मार्च 2013 है। दूसरा पार्ट है मैनर ऑफ इम्प्लीमेंटेशन, जिसमें कि RTE को दो चैनल में स्टेट को करना था। एक था RTE को स्टेट को अपने RTE रूल्स बनाने थे, दूसरा इम्प्लीमेंटिंग एक्ट और रूल का नोटिफिकेशन जारी करने। ठीक है, तीसरा पॉइंट इन्होंने जो बोला वो था डिसएडवांटेज की परिभाषा की, किन्हें हम पिछड़ा हुआ और जिनको लाभ नहीं मिल सका उस व्यक्ति के रूप में देखते हैं। तो कर्नाटक, उत्तराखंड, छत्तीसगढ़ और आंध्र प्रदेश ने अपने मॉडल रूल्स बना लिए, मतलब डेफिनेशन परिभाषा बना ली है कि वो किसको डिसएडवांटेज के रूप में देख रहे हैं, जिसमें सबसे मॉडर्न परिभाषा जो है वो राजस्थान की, जिसमें लड़कियों को भी शामिल किया गया और CWSN का यूज़ किया था, चिल्ड्रन स्पेशल नीड, उनको भी राजस्थान ने शामिल किया। और अदर स्टेट में उन्होंने ऐसा कोई उल्लेख नहीं किया था कि इन दोनों को शामिल किया गया है कि। फिर उन्होंने बोला कि दक्षिण भारत के प्राइवेट स्कूलों में डिसएडवांटेज की परिभाषा बनाने की पहल दक्षिण भारत के प्राइवेट स्कूलों ने की है, जिसमें सिंगल मदर्स को शामिल किए जाने का एग्जाम्पल इन्होंने दिया। अगला स्लाइड था इनका, राज्य के कर्तव्य क्या होने चाहिए। जैसे पड़ोस के स्कूल को आप कैसे परिभाषित करेंगे? 1 किलोमीटर दूर का स्कूल भी पड़ोस का स्कूल है और 5 किलोमीटर दूर का स्कूल भी पड़ोस का स्कूल है। दूसरी जो इसमें बात थी कि किस तरीके से ग्रांट दी जाएगी या वापस ली जाएगी, या मान्यता दी जाएगी और मान्यता वापस ली जाएगी। तो एक बात मैं स्लिप कर गई कि उसमें कमिश्नर कौन से थे जो उसके लिए अथॉरिटी होंगे।
डिपेंड्स ऑन ईच स्टेट।
अच्छा, डिपेंड्स ऑन ईच, तो वो हर राज्य के अपने जो उन्होंने रूल्स बनाए हैं उस पर निर्भर करेगा। और जहाँ पे RTE को किसी और संस्था जैसे SSA के साथ जोड़ा गया है, वहाँ मान्यता देने और वापस लेने का अधिकार भी SSA के पास ही होगा। अगला जो सबसे इम्पोर्टेंट मतलब मेरी नज़र में था, शिक्षा की गुणवत्ता के बारे में किसी भी राज्य ने कुछ नहीं कहा है। केवल उत्तराखंड में के नियमों में जो स्टेट रूल बनाए गए हैं उसमें इस तरीके की बात की गई है। स्कूलों के कर्तव्य का स्लाइड था इसके बाद, जिसमें 25% बच्चों का मामला और लर्निंग आउटकम क्या होगा, ये स्कूल का अधिकार क्षेत्र होगा। टीचर्स के कर्तव्य, शिक्षकों को ट्रेनिंग दी जाएगी। और इसका दूसरा पॉइंट मैं नहीं लिख पाई थी, श्रम का भुगतान जो है वो जो उनका वो है वो कैसे किया जाएगा। तो इसमें कुछ विशेष बात नहीं है।
ये श्रम का भुगतान नहीं है, ये जो बच्चे 25% पढ़ रहे हैं उनके अगेंस्ट में कंपनसेशन
जो है।
हाँ नहीं, ये टीचर्स वाला पॉइंट है, ये पहले हो गया।
No. Actually, it's a mistake. It should come in the earlier slide. What you're saying is correct. Compensation should come in the disadvantage
school
slide.
wala, the school, duty of the school.
You're right.
This is for teacher.
Yeah. Now, on the teachers, there are only 2 points. One is what are the qualifications, and states have generally not made any rules on qualifications. That's the first thing. The second thing is states are quiet on the relationship between the diet and the SCRT and the teachers. Only 2 states, Uttarakhand and Puducherry, have specified the relationship. No one else has specified the relationship. That's the only point. It's a bureaucratic point. How much impact it will have, I don't know.
तो यहाँ पे इनका कहने का मतलब ये है कि दो तरीके की बातें टीचर्स के साथ ही। पहला ये था कि उनका रिलेशनशिप कैसे डिफाइन किया जाएगा
with SCRT, with diet.
हाँ, SCRT, डाइट और BRC के साथ। एंड द सेकेंड पॉइंट वाज
क्वालिफिकेशन।
हाँ, दूसरा ये पॉइंट है कि उनकी शिक्षा का क्या स्तर होगा जिसमें हम मानेंगे कि इनको शिक्षक बनने के लिए योग्य ये करार दिए जाएंगे। अगला पॉइंट जो मैं एक्सप्लेन करती थी वो उनके मेहनताने का भुगतान था, जो मैं स्लिप कर रही हूँ। इसके बाद का स्लाइड जो था वो SMC के ऊपर था। उत्तराखंड, कर्नाटक और राजस्थान ने जो SMC फॉर्म करने के नियम बना लिए हैं। कुछ राज्यों में 2 तरीके के वो बनाए गए हैं, एक तो रूल बना दिए गए, दूसरे में 2 तरीके की बॉडी बनाने की बात की गई। एक जनरल बॉडी है और दूसरी एग्जीक्यूटिव, जो एग्जीक्यूट करेगी वो एक बॉडी होगी उसकी। इंटरनल और एक्सटर्नल मैकेनिज्म की बात की गई थी। लोकल बॉडी या स्टेट बॉडी में वो किस तरीके से स्टेट टू स्टेट जो है इस एसएमसी के ऊपर किस तरीके के नियम है, ये स्टेट टू स्टेट डिफर करता है क्योंकि हर स्टेट ने अपने लिए अलग नियम बनाए हैं। राज्य की सीमाओं से बाहर, हाँ, अगर मानिए आरटी में कोई प्रॉब्लम आती है तो आप राज्य की सीमाओं से बाहर अगर आप अप्रोच करना चाहते हैं तो एनसीपीसीआर एक बॉडी बनाई गई है जिसमें आप कंप्लायंसेस को लेके जा सकते हैं। अगर आपके कंप्लायंसेस यहाँ भी नहीं सुने जाते और एड्रेस नहीं किए जाते तो आप कोर्ट में जा सकते हैं और इसके लिए 25 स्कूलों का एक, जैसा मैंने समझा, 25 स्कूलों का एक केस बनाकर आप कोर्ट में ले जा सकते हैं और कोर्ट उसके आधार पर पॉलिसी में परिवर्तन के डायरेक्ट आदेश दे सकता है। ये सिस्टम ऐसा नहीं होगा कि वापस आप एजुकेशन की बॉडी में आपको भेजा जाएगा और वहाँ से कोई परिवर्तन आएगा। कोर्ट अपने आप में वो अथॉरिटी होगा जो आदेश दे देगा कि ये आपका जो प्रावधान है वो ठीक से काम नहीं कर रहा है तो इसकी जगह ये प्रावधान किया जाना चाहिए। अगला पॉइंट था रिसर्च के बारे में। आरटी वॉच रणनीति और संस्थाओं के साथ जुड़ाव। हाँ, ये इसमें सुधीर जी ने कहा था कि आने वाले 6 महीने जो हैं वो फाउंडेशन जैसी संस्थाओं के लिए भी बहुत महत्वपूर्ण है। इस समय में आप अपने लिए एक डाटाबेस तैयार कर सकते हैं और वो चीज़ें तैयार कर सकते हैं जो फील्ड में चुनौती के रूप में खड़ी है, ताकि आप उसके आगे कोई जो चेंज चाहते हैं उसको ठीक से प्रेजेंट करके और उसमें ये और इनके जो दूसरे सहयोगी हैं वो हमारी मदद करेंगे। ठीक है, तो उनका ये भी सुझाव था कि अगर हम अपने एरिया में एक बेसलाइन करें और उसके आधार पर वो चीज़ें डेवलप करें तो उसके रूल्स और बाकी आगे हम उसको कैसे लेके जा सकते हैं वो ये और इनकी टीम हमारे लिए कर सकती है। और उन्होंने ये भी सुझाव दिया कि अगर हम फील्ड में बहुत अच्छे से किसी चीज़ को करना चाहते हैं तो हम नियमों को आसान करके और उसको लोगों तक पहुंचाने और इम्प्लीमेंट करने में तो उनकी मदद करें और नियम को ठीक तरीके से प्रेजेंट करने में वो उनकी टीम हमारी मदद करेगी। मेरी तरफ से तो इतना ही है। थैंक यू।
जो अभी एसएमसी के गठन को लेके बात बड़ी महत्वपूर्ण बात आती है कि और वो है भी थोड़ा कंट्राडिक्टरी भी लगता है ये और इम्प्लीमेंटेशन में बड़ी दिक्कत है कि आपका जो एसएमसी मेंबर की बात आप कर रहे हैं वो आप 1 साल के
2 साल के लिए
नहीं, वो हर स्टेट में डिफरेंट है अमरीश जी।
हमारे यहाँ पर 1 साल है।
हाँ,
जैसे दिल्ली में 3 साल,
कर्नाटका में 3 साल है, कहीं और 5 साल है। तो
इसीलिए मैं कंट्राडिक्टरी कर रहा हूँ उसको कि एक स्टेट में 1 साल है, किसी में 2, जिसमें 3 साल है उसमें तो बहुत अच्छा है, क्योंकि आप जो है जब आप स्कूल डेवलपमेंट प्लान बनाने की बात करते हैं या अभी जो है एक जो होलिस्टिक स्कूल डेवलपमेंट प्लान की बात HRD तो ये कहता है कि ये 3 साल के लिए आपको बनाना होगा और ये प्लान आप एसएमसी के सहयोग से बनोगे, है ना। अब जहाँ पे 1 साल की है एसएमसी तो वहाँ तो बात गई, क्योंकि नेक्स्ट ईयर पे दूसरे मेंबर आएंगे तो अब उनके साथ वो स्कूल डेवलपमेंट प्लान कैसे होगा, क्या होगा। एक तो इसके लिए क्या किया जा सकता है, यानी कि या तो ये स्टेट पे ही डिपेंड है कि ये 3 साल के लिए कम से कम, मतलब ये प्राविधान अगर सेंटर से भी किए जा सकते हैं कि आप एसएमसी का अगर गठन करते हैं तो पूरे 3 साल तक के लिए करें, तब आपका स्कूल डेवलपमेंट प्लान, उसके एग्जीक्यूशन, उसकी मॉनिटरिंग और उसके डेवलपमेंट के लिए वो बड़ी आसानी से होगी।
I think it's a good advocacy point, and if we know which states have got the 1-year limit, then we should develop that as a main point that you. But that you have to go to the Vidhan Sabha, the bureaucrat, the principal secretary of education. At that level, you have to get it changed. But it can be done. There is still time.
Just to add to that, I think one of the state rules, if I'm not wrong, Chhattisgarh, for example, it's not really about the tenure of the SMC, but they've emphasized on the tenure of the school development plan itself. So the STP itself is made for 3 years.
For 3 years.
It's not for 1 year. It's not annual.
ये मॉडल रूल्स में है।
SMC is for 1 year.
SDP 3 साल के लिए बनानी है, ये मॉडल रूल में।
सेकंड चीज मैं ये कह रहा था कि NCPCR और SCPCR इनका जो अभ्युदय कहेंगे या इनका जो पूरे फलक पे आना ये RTE के बाद हुआ है। जैसे ही राइट टू एजुकेशन आया तब आपका SCPCR और NCPCR जो है बिल्कुल एक्स्ट्रा ऑर्डिनरी जो है ये चार्ज हुई है। लेकिन जब हम इनकी कार्यप्रणाली को देखते हैं तो आपका जो SCPCR, मैं उत्तराखंड के परिप्रेक्ष्य में बोल रहा हूँ, संभव तो सारे राज्यों में ऐसी स्थिति हो सकती है। जब SCPCR की कार्यप्रणाली देखते हैं या वहाँ के जो आयोग का अध्यक्ष है उसकी समझ हम देखते हैं, उसका पर्सपेक्टिव देखते हैं, तो उसकी समझ RTE को लेके नहीं
पॉलिटिकल आता
है, वो पॉलिटिकल है। दूसरा वो जो है मुख्य रूप से जो है जो ये बाल एवं क्या है महिला बाल कल्याण विभाग के द्वारा नामित व्यक्ति उसमें वो है SCPCR। उसके जो मेंबर हैं उसके मेंबर भी पूरे के पूरे पॉलिटिकल हैं। ठीक, उत्तराखंड में दुर्भाग्य क्या हुआ कि उसी SCPCR को जो एग्जिस्ट कर रहा था उस स्टेट ने उठा करके RTE एक्ट की मॉनिटरिंग, RTE एक्ट का जो है सारी चीजें उस SCPCR को। अब अभी दिक्कत क्या है? दिक्कत यह है कि लोगों को पता ही नहीं है कि ये SCPCR है, ये वही वाला है या कोई और है। तो एक तो जो SCPCR और NCPCR के लिए कौन से लोग उसमें नामित किए जाने चाहिए, कौन से सदस्य होने चाहिए, उसकी एक स्पष्ट जो है, मैं अभी अपने स्टेट की SCPCR के लिए जो बजट जारी किया गया था वो देख रहा था, तो वो किसी समय का है, बहुत पुराना है। तो RTE के परिप्रेक्ष्य में फिर से सारे स्टेट के लिए हमको मुझे लग रहा है कि ये एडवोकेसी करनी होगी कि आपका जो SCPCR है उसके लिए जो गाइडलाइन या उसके जो क्राइटेरिया है उसको आपको जो है पुनः एक बार देखना पड़ेगा।
I think that's a good point as well. It's a good point, and also I think in some states they have district level authorities, which is very important. But I'm talking about SCPCR as a state. You can see SCPCR state. I know it's a state committee, but they have reception nodal centers in the districts in some states. That will become very important if you want grievances to go.
Then third, अभी तीसरा जो है जो हम इसकी बात कर रहे हैं, ये पूरा एजुकेशन सिस्टम से जुड़ा हुआ है। फिर से एक बार मुद्दा आपका अलाइनमेंट का। आपने जो अथॉरिटी बनाई है, लोकल अथॉरिटी है ना, या ग्रीवेंसेस रिड्रेसल के लिए जिसे ऑथराइज्ड किया है, वो पूरा का पूरा जो है आपका स्टेट गवर्नमेंट का एजुकेशन डायरेक्टर को उसने सबसे ऊपर माना है। अगर वो किसी स्कूल की मान्यता को खत्म करना चाहे या किसी स्कूल पे कोई एक्शन लेना है तो वो लेना है आपके डायरेक्टर एजुकेशन। यहाँ दुर्भाग्य क्या है, और उससे नीचे जो लोकल अथॉरिटी है उत्तराखंड में, उसको पूरे तरीके से गवर्नमेंट ने अपने हाथ में लिया। उसमें कम्युनिटी का कोई मेंबर नहीं है, और उसमें जिस लोकल अथॉरिटी की अवधारणा जो मूल अवधारणा है उससे लिंक नहीं हो रहा है। आप उसको ये जरूर कह रहे हैं कि वो बहुत अच्छी व्यवस्था है, इसमें पूरी तरीके से गवर्नमेंट के लोग हैं, यानी कि ब्लॉक लेवल पे आपका BO है ना, डिस्ट्रिक्ट लेवल पे आपका DO है। अचानक क्या होता है कि आपकी जो एजुकेशन का जो स्ट्रक्चर है वो स्ट्रक्चर चेंज हो जाता है। ठीक, अब आपने अपना जो है RTE इंप्लीमेंटेशन के लिए 3 साल के लिए बना लिया है, स्ट्रक्चर आपका फर्स्ट ईयर में चेंज हो जाता है। अभी अपने यहाँ क्या हो गया है कि DO से बदल के CO, चीफ एजुकेशन ऑफिसर इज द टॉप मोस्ट ऑफिसर ऑफ डिस्ट्रिक्ट। ठीक, आपकी जो परिभाषा है वो डिस्ट्रिक्ट एजुकेशन ऑफिसर की है? अब ये जो CEO है, मतलब वो ऑटोमेटिकली उसके जो अधिकार हैं वो शिफ्ट हो जाते हैं CO कि DO का मतलब CO बनना चाहिए, सिंपल सा लेटर निकालना है। लेकिन CEO की व्यवस्था मतलब स्थिति ये है कि उसका SSA से कोई लेना देना नहीं, और SSA जो है आपकी RTE इंप्लीमेंटिंग एजेंसी है। तो अब कोई भी पर्सन फॉर एसएसए और बीओ बना रखा आपने जो है आरटीई के ग्रीवेंस रिड्रेसल का अधिकारी। तो ये जो इस तरीके की जो बातें हैं या इस तरीके का जो सिस्टम क्रिएट हुआ है, ये भी बहुत बड़ी दिक्कत करेगा।
Can I say two things? The first is on the composition of SCPCRs. So I don't think that you can challenge the composition of SCPCRs per se. The only thing you can do is you can show that SCPCRs are not working. But for that, you will need to show that they are not working over a reasonable period. Maybe if you track your state SCPCR for 1 year, then in 2014 you can make a very serious. But for that, you have to give them grievances. Only if they are not solving the grievances can you show that they are not working. If they still don't work, then there can be an interesting strategy of either putting pressure on the government or going to the court to order that the SCPCR should be reconstituted. It's a possibility. I would say that. But per se, you can't say that this person is a political person or does not have a education background and hence should be replaced. Nobody will agree to that. The second thing I would say is that, and I noticed that in your responses through the day, is that you have a very deep sense of the education bureaucracy. But I would almost advise you not to get so deeply involved. Because ultimately, the structures of government are its problem. That is the difference between an executive delivered welfare program and a statutory entitlements program. It does not matter who is DEO or whether he is CEO or whether he is from Sarva Shiksha Abhiyan or whether he is from education bureaucracy, it doesn't matter. At the end of the day, he has to deliver. If he doesn't deliver, you can get it enforced. And that is the power of a statutory entitlement welfare system. So you should not get so obsessed because it's also a sort of, it's so deep set in our cultural understanding of government practice. And if you ever, and I'm sure all of you do this, if you sit in a Tahsildar's office for half a day, the whole day will be spent only discussing intergovernmental, intra-office issues. There is nothing else to do in government. This is all the work of government is. So we should not become version 2 of that system. They are only obsessed about whether your name is DEO or CEO or whether how the CEO is related to this, whether this person has seniority, and whether X person has a car or Y person has this TA and DA. This is the everyday state practice. In some ways, the challenge is to know it. We need to know it. We need to understand it. But we shouldn't be in it. Because we need to have the critical distance to say, after a point, it doesn't really matter. They have to deliver it on the ground. And that's the focus that I would bring to them. Understanding the texture of government is important, but it should not just be the whole thing. Yes, sir.
मेरा एसएमसी के बारे में कुछ समझना भी था और कुछ शेयर भी करना था। दूसरे राज्यों के एसएमसी के क्या हालत हैं, शायद अगर वो 3 साल की वकालत करते हैं कि 3 साल अगर एसएमसी को गठित होना चाहिए तो वहाँ के एसएमसीज के हालत अच्छे होंगे। राजस्थान में भी 2 वर्ष के लिए अभी पुनर्गठन हुआ है अभी 3 दिसंबर को, तो ज़्यादा हालत संतोषजनक नहीं है। अगर हम अनेबल एसएमसीज को अगर 3 साल के लिए चुन लेंगे तो वो ढाक के 3 बात होंगे, कोई ज़्यादा चेंज होने वाला नहीं। तो हम पहले जो कम्युनिटी लेवल पर जो स्कूल के जो हमारे जो कम्युनिटी मेंबर हैं वो तो समझें इसको कि भाई असल में हमारी क्या भागीदारी है स्कूल के डेवलपमेंट में। ये बहुत बड़ा इशू है।
I agree with you that 1, 2 or 3 years is important but not the whole question. Can there be participatory school management is the critical question, and that is not clear. But I think the evidence from Karnataka is quite positive. But I think SMC process in Karnataka is almost 10 years old. And I think now SMCs are starting to take ownership, at least in the rural school sector, not in urban schools. But in the rural school sector, there's some impact of SMCs. So I'm not that pessimistic. It can happen, and we must try and see what has worked in Karnataka, why it has worked, and try and take some of those ideas and adopt them as rules in other SMCs. I think that is the
क्योंकि पिछली बार जो एसएमसी का गठन हुआ उस समय एक फौरी इन्फॉर्मेशन थी ग्रासरूट लेवल तक, फिर इस बार थोड़ी सी गवर्नमेंट की तरफ से थोड़ा पुश था कि इस बार तो होना ही चाहिए इस पर रूल, और अधिकारियों को निर्देश थे। एमटी जयपुर स्तर से ट्रेनिंग करके जिले स्तर पर दे रहे हैं, रिसोर्स पर्सन को दे रहे हैं, रिसोर्स पर्सन नोडल अधिकारियों को दे रहे हैं, नोडल एचएम को दे रहे हैं, तो इस तरह से वो चल रहा है। लेकिन मैंने तीनों ही जगह जाके ऑब्जर्व किया, जब तो लास्ट स्टेज में भी जो मीटिंग हो रही थी उसमें मैं था, तो उन्होंने कहा कि पिछली बार हो गई गठिन, इस बार भी हो जाएगी, आपको टेंशन लेने की जरूरत नहीं। तो ये स्थिति है। तो सेंसिटाइजेशन या इस पूरी चीज की अंडरस्टैंडिंग, ये बहुत बड़ा एक लोचा है अभी भी यहाँ।
Yeah, but I think that it's not clear to me that SMCs must necessarily become the centerpiece of the act. Some education activists believe that the school management committee is the most important institution in the entire education structure. I'm not sure. Maybe it is. Maybe it will come 10 years later. But in the initial stages, it might be other institutions that we must be concerned about.
क्योंकि गवर्नमेंट में सिस्टम में तो बदलाव होता रहेगा, सीओ डीओ बनेगा, डीओ जो भी बनेगा, स्कूल के टीचर भी आएंगे जाएंगे, लेकिन कम्युनिटी का जो बेस है, अगर एसएमसीज मजबूत होती है तो गुणवत्ता की या उस स्कूल के सिस्टमेटिक काम होने की उम्मीद कर सकते हैं।
Because it is a community based initiative, I think it can only be a long term objective.
Yes.
It cannot be a short term. I doubt whether in a short period you can get big outcomes. There's one question.
दो सवाल हैं मेरे, और इनकी एक सवाल बहुत है और सवाल लेने पड़ेंगे। चाय हम इनके अंदर पी लेंगे। नहीं, रोहित जी के सेशन थोड़ा सा रोकना पड़ेगा, क्योंकि वो इनकी आज लीगल व्यक्ति मिले हैं और बहुत दिनों से इंतजार था। सबसे पहली बात तो ये लोकल अथॉरिटी जो है, अगर मैं एक ब्लॉक में हूँ, डेवलपमेंटल जो ब्लॉक है उसमें अगर कोई बात करता हूँ, तो मैं ये मानता हूँ कि वहाँ पे ब्लॉक एजुकेशन ऑफिसर लोकल अथॉरिटी का हेड। लेकिन ब्लॉक एजुकेशन ऑफिसर को अगर हम देखें तो वो बीडीओ के अंडर में, बीडीओ इज सीनियर देन। और अगर सच में अगर हम उसके और ज़्यादा देखें तो सच में ब्लॉक जिसके यानी कि जिसका जुरिडिक्शन है वो प्रधान के कब्जे में है, यानी कि वो पॉलिटिकल पोस्ट है। तो असल में लोकल अथॉरिटी में मुझे एक गांव में अगर से मुकदमा करना है तो मैं लोकल अथॉरिटी को सीधा नाम लेके करूंगा, तो मैं प्रधान जी को करूं अपना यानी कि वर्षित प्रधान जी बनाऊं या बीओ बनाऊं या बीडीओ बनाऊं, इन तीनों में से कौन होगा। दूसरी बात, अगर मैं बीओ को बनाता हूं तो बीओ एक ऐसा व्यक्ति है लोकल अथॉरिटी में, ब्लॉक चूंकि सबसे छोटा एक हिस्सा है, जो व्यक्ति है विदाउट पावर। उसके पास एक मास्टर को यहां से यहां बिठाने की भी पावर नहीं है, तो उसको क्यों बेचारे को मार दिया? एक तो ये सवाल। दूसरा एक सवाल ये है कि पेरेंट्स की ड्यूटी के रूप में रखा गया कि पेरेंट्स की ड्यूटी है कि वो अपने बच्चों को स्कूल भेजें। मैंने कुछ लोगों को अभी पिछले 1 साल से मैं लगातार सुनता आ रहा हूँ, वो लोग ये कह रहे हैं कि पेरेंट्स को भी आरटीई के तहत, चूंकि गवर्नमेंट ने कंपलसरी एजुकेशन कह दिया और स्कूल टाइम में आप बच्चों को घर नहीं रख सकते, इसलिए कोई पेरेंट्स पर भी केस बन सकता है। क्या ऐसा है तो कैसे? तीसरा सवाल, यानी कि जहाँ जहाँ पर हुआ है वो तो बहुत बड़ा यानी कि गड़बड़ कर दिया है। सर्व शिक्षा अभियान एक प्रोजेक्ट है जो 2000 में निकल के आता है हिंदुस्तान में। अगर उसकी चीफ एग्जीक्यूटिव ऑफिसर्स को रिकॉग्निशन जैसी पावर दे दी गई तो ये इतना ब्लंडर मिस्टेक क्यों गई? एक प्रोजेक्ट के व्यक्ति को और एक प्रोजेक्ट के सीईओ को ये पावर दी नहीं जानी चाहिए कभी भी, यानी कि वहां पे डायरेक्टर पब्लिक इंस्ट्रक्शन है, उसकी जिम्मेदारी होनी चाहिए थी।
राजस्थान में है ये व्यवस्था?
नहीं है जी।
नहीं,
अगर देखिए क्या राजस्थान में ये नहीं है, राजस्थान में डायरेक्टर के पास पावर है। ये किसमें, ये नहीं कि वो तो राज्य बता दें फिर उसको पता कर लेंगे। राजस्थान में ये नहीं है। राजस्थान में डायरेक्ट पब्लिक इंस्ट्रक्शन जो है बीकानेर बैठता है, वहां से उसी से लेटर जारी होता है, या कमिश्नर है कुछ, लेकिन कमिश्नर ये पावर नहीं है कि वो किसी की मान्यता को विड्रॉ कर सके। कमिश्नर तो एक मास्टर जी की अब यानी कि को 10 दिन के लिए ट्रेनिंग पे बुलाना है, इसके लिए भी पावरफुल नहीं है। तीसरा, राजस्थान में की इन्फॉर्मेशन है, राजस्थान में भी एसएमसी टूटा है। यहाँ पर जनरल बॉडी है, यहाँ पर एग्जीक्यूटिव है। और ये जो आपने कर्नाटक के जो काम कहे, यानी कि इससे ऊपर राज्य के काम कहे, ये सभी काम करती है वो। और फर्स्ट टाइम यानी कि जब भी कोई शिकायत होगी उसके लिए फर्स्ट टाइम के लिए भी ये बात करेगी। तो ये थे। एक राजस्थान में एक और एडिशन है कि CSWN की बात की है, और उसने इकोनॉमिकल बैकवर्ड के उसको लोगों को भी शामिल किया। और राजस्थान में 2.4 लाख रुपीस का एक नॉर्म रखा है, जिसमें हर क्लर्क के बच्चे उसमें शामिल हो सकते हैं।
वीरेंद्र जी ने बड़े गहरे सवाल उठाए हैं। मैं तो बहुत जिज्ञासा मेरी थी, तो बहुत छोटे से सवाल हैं। एक्ट इसके बारे में क्या कहता है वो मैं थोड़ा सा समझना चाह रहा था कि इंफ्रास्ट्रक्चर के बारे में जो एक शेड्यूल दिया है कि भाई क्या क्या स्कूल्स में होना चाहिए, तो ये जब से लागू हुआ है उसके बाद की स्थितियों के लिए है या पहले से जो स्कूल चले आ रहे हैं उनमें भी ये लागू होगा, नंबर 1। और अगर पहले वाली स्कूलों पर भी ये लागू होगा तो शहरी क्षेत्र में खास तौर से जहाँ पर जमीन नहीं है, तो अब क्या वहाँ पर डिमोलिश किया जाएगा आसपास के मकानों को? क्या सरकार कोई ऐसी पॉलिसी लेकर आने वाली है कि स्कूल के लिए जमीन एक्वायर कर सके जैसे बाकी पब्लिक कॉज के लिए एक्वायर करती है? एक तो ये जिज्ञासा थी। दूसरी ये है कि बहुत सारे NGO राजस्थान में स्कूलों में सपोर्ट कर रहे हैं, गवर्नमेंट स्कूल्स में सपोर्ट करते हैं जा करके, एंड वो टीचर की जो मिनिमम क्वालिफिकेशन RTE तय करता है उसको फुलफिल नहीं करते वो लोग। तो क्या इन लोगों के ऊपर RTE लागू होगा कि नहीं होगा? क्या इसको हम मानेंगे कि भाई ये सरकारी स्कूल में जाके कुछ इनपुट दे सकते हैं कि नहीं दे सकते हैं? और अगर नहीं दे सकते हैं तो फिर बहुत सारे हमारे जैसे लोगों की क्या भूमिका होगी?
शाला प्रबंधन समिति को लेकर अभी जो हम बात कर रहे हैं, काफी महत्वपूर्ण भूमिका RTE के कमेटी को दी गई है। लेकिन इसी के साथ साथ जो पंचायती राज सिस्टम है, जिसमें आपकी स्टैंडिंग कमेटी बनी हुई शिक्षा, स्वास्थ्य और समाज कल्याण नाम की एक समिति है, उसके साथ में इसका कोई ऑर्गेनिक लिंक नहीं। ऐसा लगता है कि SMC फॉर्म करने के कारण पंचायत राज संस्थान है वो डिसएम्पावर होता है। ये एक पैरेलल स्ट्रक्चर के रूप में उसमें नजर आता है। ये बात ठीक है, उसमें 2 पंचायत के रिप्रेजेंटेटिव का रिप्रेजेंटेशन सुनिश्चित किया गया, लेकिन उसका ये मतलब नहीं है कि सारी की सारी पंचायत के निगरानी में ये सारे काम हो रहे होंगे। वो उसको सीधा बाईपास करता है और सीधा लोकल अथॉरिटी, जो कि जिला पंचायत मध्य प्रदेश के कंटेक्स्ट में कहूँगा, वहाँ के CO को रिपोर्ट करते हैं और 30 डेज के भीतर में उसके ऊपर में कार्रवाई करने की बात होती है। लेकिन राजस्थान और अदर स्टेट में भी शायद ये कंफ्लिक्टिंग सिचुएशन होगा दोनों के बीच, जब तक कि ऑर्गेनिक लिंकेज, मेरा मतलब इसमें साफ है, रिपोर्टिंग एक मैकेनिज्म होना चाहिए कि SMC जो है वो ग्राम सभा और पंचायत राज इंस्टीट्यूशन के प्रति जवाबदेह होगी, नहीं होगी, और होगी तो किस प्रकार से होगी, उनका रिपोर्टिंग मैकेनिज्म क्या होगा, ये उसमें आना चाहिए।
Okay, I'll just start with the last question. I think it's an interesting question, and it seems to be a premise of most public activism in India that if an organic linkage between the SMC and the panchayat were to take place, why would we be happy with it? We'd be happy with it, I think, because we think that this linkage establishes democratic legitimacy, right? But it's a curious view of the nature of politics and the nature of democracy, peculiar in some ways to India. Because it's only in India that the MLAs will insist that they must decide who the contractor who receives the bridge contract, they must be on the committee that decides in their constituency who the bridge contract goes to. Nowhere else in the world does the idea of democracy include the idea that the legislator controls executive functions. Nowhere else in the world. Let's take an example. The United States, which has a very well developed school system, has a school district system which administers education, public education. The school districts are not, there are no elected members as a part of the school district at all. Not one. No senators, no city councillors, no mayors. The school district system has an election system where parents are a part of the school district. You have to stand for election and get elected, but no connection to the political process. Is that democratic? Is that legitimate? I think it is. So I am not one of those who argue that the only form of democratic legitimacy is in the elected representative. I think the failure of that argument is there for all of us to see, and I don't think that we should push for electoral representation of this sort, political party electoral representation in all spaces, as if that is the only form of democratic legitimacy. So I would not be the one to argue for an SMC panchayat linkage. I think the two of them can operate independently and can both be successful. It's good to keep these zones separate. On the infrastructure question, 3 years is the period given to existing schools. For new schools, from the date of application, they must have all the facilities. So that is the way the RTE Act operates. But your question was, now what do we do with old schools that don't have the facilities? It is going to become a very serious question. After June 2013, they will have to decide either that they amend the Act and give 3 more years or something like that, or they have to create some limited exception for schools in densely populated areas. Maybe they will say something like, where population is more than, I don't know, what is it, maybe 500 per square kilometer population density, which will cover urban areas, that some of these scheduled facilities need not be provided. It's a possibility. You want to add?
Yeah, I think the MHRD has already started issuing guidelines in this regard. I think the latest one that they came out with was a relaxation on playgrounds in urban areas, for example. They've said that schools can access public playgrounds and it's not necessary that they have their own playground. So I think, we don't know how that will shape up.
Yeah, and just to put a comparative lens on this, the Schedule 1 of the RTE Act is a little strange in all the things it sets out. Because if we were to take this and apply it to schools, say in Western Europe or in North America, many schools in these settings would not satisfy the RTE. So it's interesting how the Schedule 1 infrastructural parameters have come to shape the way we think about basic requirements, infrastructure requirements. But to answer your question more forthrightly, I don't think that easy solutions is available. They will have to make some compromising. Yeah. So there were 3 questions and I'll respond in a minute. So one of you made some observations about economically backward classes, Rajasthan, the reservations, and the complaints in the SMC process, which I don't need to say anything more. I just take those as being clarifications. I guess you had 2 main institutional questions, the way I understood it. The first was about the BEO being a powerless authority, and the second one was about project CEOs and Sarva Shiksha Abhiyan being very powerful authorities. I take both of them to be versions of the same question, which is, what is the best institutional architecture for the implementation of the RTE? Who should be given more power? Who should be given less power? I'll just repeat what I said earlier this morning, which is that in some ways I am not invested in that question. I don't have any determinate view that the Indian bureaucracy as it exists has a perpetual right to exist and to be made more powerful. It has no such right in my mind. My question, the way I approach this issue is to ask what is working in terms of institutional design for the delivery of social welfare. If the Sarva Shiksha Abhiyan agency mission approach is effective, then so be it. Let it deliver the goods. If the district education bureaucracy is effective, then by all means empower it. But I don't think that without paying attention to the local context and the situation in each state and maybe even down to the block level, that there is one answer to that question. So if the BEO is particularly powerless in Rajasthan, I would like to know why, if that BEO had more power, would they do the right thing? It's a question that pops up at the back of my mind. So that's how I think about institutional questions, just as a short response.
Thank you, Sudhir ji, for being with us. I mean, let me take this opportunity.